I just recorded a video on the importance of a properly drafted, durable power of attorney for property management. And in there, I made a reference to what we call in California an advanced healthcare directive, or what other states refer to as a durable power of attorney for healthcare. So this is the companion video from the financial side. Now we're going to address more of the medical side, but the idea is still the same. It's a document that allows someone to make medical decisions for you if you're unable to make those decisions for yourself. Again, and we want to call it a durable power because we want that power of attorney to be able to exist beyond the principal's incapacity. That's the main reason for it. And so there are very important things that are included inside that advanced healthcare directive, which primarily says that you're designating an agent. In this case, an agent, it could be a spouse, an adult child, a good friend of yours, an agent to make medical decisions for you to the same extent that you could have made those decisions yourself had you had the capacity to do so. So these powers of attorney in healthcare as well as property management are called documents of substituted judgment. Again, somebody is stepping in your shoes and making the decisions for you because you were otherwise unable to make them for yourself. Again, go back to the word durable power of attorney. So here you have one that falls into just regular making medical decisions. Who makes the decisions for you if you're unable to make them for yourself? Secondly, not only the power to make a decision, but what about your particular feelings about under some circumstances you may not want to receive medical care? In other states, this is referred to as a living will. Don't confuse it with a last will. It's a living will. It's where you have an affirmative statement that says typically if you're diagnosed with an incurable, irreversible coma, or you're effectively brain dead as a result of a persistent vegetative state, and but for the human intervention, your body would have naturally expired within a couple of months or weeks or days or anything lesser included, and you're only artificially delaying the moment of your passing. Most people would put a statement saying that under those circumstances, remove human intervention. Pull the plug, as we say colloquially. Pull the plug. Save my family the financial stress, not to mention the emotional stress of dealing with all of this. And as a result, let my body do what it's going to do. Very, very important. And the big landmark case that put this on the map was that Terry Schiavo case about 20 or so years ago, where you had basically a spouse as well as a parents. A spouse was saying, I know Terry was incapacitated. Pull the plug, pull the plug, pull the plug. And the parents were saying, no, no, no. We want to wait for, we want to, we want to see what happens. And as a result, there was a conflict. The state of Florida couldn't get involved because we had two different interested parties, and 20 years or however long it took, many years later with the media circus, went all the way to the Supreme Court of Florida. And ultimately they wound up pulling the plug on Terry. And so and that was because there was no what we call clear and convincing evidence of what Terry herself wanted. So here, inside a properly drafted durable power of attorney coupled with a living will, or what we call here in California an advanced healthcare directive, it's built in, you would have a statement regarding under those narrow circumstances what to do. But even though you may remove medical intervention, you still want to receive as much medical attention and care for your comfort and to alleviate pain. So it's also very important that you have that power to still receive medical care for your for comfort and for pain alleviation. But then you have other things that are important in there also. What about anatomical gifting? How do you feel about organ donation? Some people say yes, organ donation. Some people say no in organ donation. They may have an indicator on their driver's license saying that yes, they're going to be an organ donor, but yet there's no clear direction as to what is meant by that. It's just a yes under what's called the Uniform Anatomical Gifting Act. So sometimes these powers of attorney can help us give direction. And what experience has shown me over the years that when people said, yes, I want to be an organ donor, the substantial majority said, well, what they had in their mind was, as long as I'm helping another human being directly, like an organ donation, or maybe a liver transplant or a heart transplant, where they're helping someone directly. But just saying yes leaves it to the discretion of the agent, and they could wind up using your body for medical research or as a teaching cadaver. You didn't give any limitations. So one of the very important powers, written instructions in this power of attorney for healthcare is to make sure you have a limitation. Is it anybody, including institutions, the universities and medical schools and forensics, Or do you mean so long as I help a human being, I'm okay with it? Or no, I only want my immediate family, spouse, and kids, and nobody else? Or no, I don't want anything. I want to be this kind of kept whole, so to speak. And secondly, I think thirdly, now we have also, how do you feel about funeral arrangements? Burials versus cremations. Very important that you make a note inside there as to about how you feel about memorial services. I already made reference to it earlier in the video here about quality of life, long-term care. There should be a statement that says if you require long-term care, you want to stay at home and maintain your privacy and independence as long as possible and have that care brought to you. But also you may recognize that there could come a point in time where that degree of care cannot be delivered to you either because of your own physical or mental safety. And if you do require a care facility, you want one that's the least restrictive, most home-like setting, close to friends and family, that offers social interactions and outdoor activities. These are just things that you want so you can be treated with a degree of dignity. And therefore, you have some statement that's written about that. So if you aren't treated with a degree of dignity, somebody, typically the kids or a good friend, at least can have a claim for elder abuse if the agent is not treating you with that level of degree of dignity. So and also this, I guess, lastly thing to mention is that most recent updated powers of attorney for healthcare, the last 4 or 5 years, have built in HIPAA, which is the Healthcare Information Portability and Accountability Act, which allows the medical institutions to release information to the agents so they can make informed decisions. So just being listed as an agent doesn't guarantee you're going to get the doctors to talk to you. So here, having the HIPAA releases inside there, and here in California, we have our own California Medical Information Act in there as well. So if your state has something similar, then you would have that inside there as well. So the doctors and hospitals can give the agent enough information so they can make informed decisions. After all, that's the job that you're empowering them with. So if you have a power of attorney that's a little bit older, or you don't have one, give me a call. Let's talk about this, okay? It's very important documents, how you feel about your medical care, long-term care, end-of-life decisions, et cetera, et cetera. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all of your tomorrows. Thanks for your attention. Bye-bye.